Hello guys, welcome to LawPutra YouTube channel. I am Bhavna here. Today we are gonna discussing about the topic in our Indian Constitution, Article 245, which says about doctrine of territorial nexus. As we all know, the essential feature of our Indian Constitution is a federal form of government. The federal form of government means the power will be distributed equally between central government and the state government. Okay, the essential feature of our constitution is a federal form of government. The federal form of government means the powers will be distributed by the central government and state government. Central legislative body plus state legislative body equals to legislative relations. Okay, the powers distributed by the parliament are central government and state government. So the central legislative body plus state legislative body is equals to legislative powers. Okay, the function of legislative body is to make laws. Okay, remember, the function of legislative body is to make laws. Legislative relations have been dealt under Part 9 of Indian Constitution from Article 245 to 255. Now we are discussing about Article 245. Constitution of India makes a two-fold distribution of powers in legislative relations. Okay, Constitution of India makes a two-fold distribution of powers in legislative relations. Legislative relations in respect with the territory, with respect to the subject matter. With respect to territory comes under Article 245 and with respect to subject matter comes under Article 246. In Article 246, state list, concurrent list and union list will be discussed. Now let's see Article 245. Article 245 is a territorial jurisdiction with respect to laws made by the Parliament and the state legislature. It means the territorial jurisdiction with respect to laws made by the central and the state legislatures. Okay, in clause 1 of Article 245 says about Parliament may make laws for the whole or any part of the territory of India, which means Parliament can make any laws with respect to the whole part of the territory of India or any part of the territorial India, and the state legislature may make laws for the whole or any part of state, which means the Parliament can make to the whole part of territory of India and state can make whole or any part of the state. Okay, this is under clause 1. Now let's see about clause 2. Clause 2 says about extraterritorial operation. Okay, let's see the meaning. What is extraterritorial operation? No law made by the Parliament shall be denounced to be invalid on the grounds that it would have been extraterritorial operation. Okay, by discussing about the doctrine of territorial nexus, we can easily understand the clause 2 of Article 245, extraterritorial operation. Now let's see the object of Article 245. The object of the Article 245 is the object to which the law applies need not to be physically located within the territorial boundaries. Here clearly understand that the need not to be physically located within the territorial boundaries. Okay, now let's see what is doctrine of territorial nexus. The meaning of territory means boundaries and nexus means connection or relations. In the doctrine of territorial nexus, the territory means boundaries and the nexus means relations or connections. The doctrine says that the laws made by a state legislature are not applicable outside that state except when there is a sufficient nexus between the state and the object. Okay, here the doctrine says that the laws made by the state legislature are not applicable outside that state, except, here there is an exception, except when there is a sufficient nexus between the state and the object. Let's see this with an example. Suppose a company was found in Hyderabad and its branch was established in Gujarat. Okay, so as there is a branch in Gujarat, the taxes of that branch will be applied according to that state, not according to the Hyderabad. Okay, as though it was found in Hyderabad, there is a branch in Gujarat, right? The taxes will be imposed according to the Gujarat state, as there is a territorial nexus between the state and the object. The doctrine of territorial nexus can be invoked under the following circumstances. Firstly, whether a particular state has extraterritorial operations. which means according to Article 245 Clause 2, extraterritorial operations means no law made by the Parliament shall be deemed to be invalid on the grounds that it would have extraterritorial operations. Means that Parliament shall not be deemed to be invalid on the grounds that it would have extraterritorial operation. And second point, if there is a territorial nexus between the subject matter of the act and the state making law. There is a territorial nexus between the subject matter of the act and the state making of the law. This is all about the doctrine of territorial nexus. The doctrine of territorial nexus derives its authority from Article 245 of India. This is all about Article 245 and doctrine of territorial nexus. The famous case laws of doctrine of territorial nexus is Wallace Bros and Co. versus Income Tax Commissioner Bombay in year 1948 and Tata Iron and Steel Company versus Bihar State of Tax Act in the year 1958. These are the important case laws of Article 245 and Doctrine of Territorial Nexus. I hope you all clear with the video. If you have any queries, please leave it in the comment section. Please do like, share, comment and subscribe to LawPutra YouTube channel. Thank you.